Hey, I apologize for starting late. We're experiencing technical difficulties. As you know, that stage right, your left monitor died, what, a month ago, month and a half? And then stage left, your right monitor, I think someone finally put it out of its misery. It was flickering a vague message earlier. And then the big screen over here had a little thing at the bottom that said, time to replace the light bulb. So that's not working either. And then this was the backup monitor for the stage right that died, but it wasn't working.
Right on the whiteboard.
Right, yes, I just stenciled the slides on there. I prepared these slides for you. Maybe they're not works of art, but they're much better than I can draw on that whiteboard. I swear to you about that. Yeah, that's about all you can. So anyway, also the little clicker there that I advanced the slides with, that's dead again. As you know, I bring my own batteries to refresh that, but my own batteries didn't fix it this time. So I've got to stand near the keyboard, which is difficult because I've also got to be near the one working monitor, which I managed to get working by unplugging all this stuff. And I don't know what I unplugged. So maybe you've got my back when security comes in and says, you know, why are all these dead monitors and dead projectors unplugged? You know, it's because my heart was in the right place. I wanted to at least get this one working. So anyway, it looks like I'll be standing within these 3 inches because I gotta reach the keyboard, but yet I gotta be in front of the monitor for our good folks out there in YouTube land. Hello, good folks in YouTube land. So up to 1,450 subscribers last time I checked. So there's 50 of you here. So somebody's watching other than y'all. So hello, whoever you are. Thank you for joining us. So, yeah, I don't want to let them down and not have some slides. As for the lighting and the glare, I don't know where to start. But my face ain't that pretty anyway, so who cares if it's lit up, right? Yes. So you had to agree with that one, huh? All the things I say in here, that's the thing you agree with, huh? I don't blame you, though. The truth is the truth. Who can deny the truth? Who can deny? Who can deny? So anyway, for those multitudes of reasons, I started late today, and I apologize. I'll just end late to make up for it. Nah, just kidding. I'll still get you out of here on time. You shouldn't have to pay the price. So today's lecture, we finish up Homestead, but after that, we segue into taxation. You can't tax me like that, is what the theme of our lecture shall be. Because many states impose a greater tax burden than the state of Florida that we stand in here today. Some might even call Florida, relatively speaking to other states, America's tax haven. That's an exaggeration. We certainly pay our fair share of taxes here. But of course, we don't have a state income tax. That's beautiful. We do have a taxpayer's Bill of Rights required by our Constitution. That's beautiful. Our Constitution of the state of Florida, Article 1, is the Declaration of Rights. And within that Declaration of Rights is the requirement that there be a taxpayer's Bill of Rights. So right up there with freedom of speech, freedom of the press, freedom of religion is the right to have a taxpayer's Bill of Rights. That's how important fair taxation is to the drafters of the Constitution of the state of Florida. So whether or not Florida is a tax haven, I'll let you decide that when we get to that part of our lecture. But before we get there, we did have a few items to cover from last week's Homestead lecture. You know from our syllabus that I intended to cover Homestead both yesterday and today, and that's why before we get to taxation, we got just a little bit more Homestead to cover. And before we get to Homestead, I thank you once again for indulging me. You've allowed me to begin every class this semester with a prayer, and I will do so again. As always, I'm not praying at you, I'm praying for you, praying for your success. Perhaps you got my email within the past couple of days. I'd like to do the housekeeping through email so I don't waste your time here in class. I told you about a review video you can see. I told you about some information about the graded essay. And I also cordially invited you to the Red Mass that is happening in downtown Orlando at 12:10 p.m. tomorrow. The Red Mass is a tradition that began in the year 1275 or something like that. So when it comes to Catholicism, it's a new thing. And it is hosted by the Bishop of Orlando, John Noonan. He and me and my wife cordially invite you to attend the Mass if you choose to do so. It's always been well attended, always been attended by all faiths, because we're praying for all faiths. We're praying for everyone in the legal community, be they paralegal, law student, law professor, lawyer, judge, magistrate, anyone involved, clerk of court, anyone involved in the legal profession. And with that noted, I begin this class as I begin every class with a prayer. And as always, I pray in the name of the Father and of the Son and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. All you good saints of heaven, pray for those in the judiciary, in the legal field, and in the legal profession, so that they might do their part toward justice in this world. Amen. In the name of the Father, Son, Holy Spirit. Amen. Okay. Homestead. Do you think you've got your head wrapped around it from our last lecture? Oh, look at me. I'm clicking the clicker. It doesn't work. Gotta hit the keyboard. Homestead. Yes. Do you think you've got your head wrapped around it? I hope you do. But just to make sure you do, we do wrap up our homestead discussion. We are looking at co-ownership types. And we've asked whether the homestead exemption from forced sale may inure to co-owners. And in so doing, we've already looked at tenancy by the entireties. You remember our discussion. We've looked at tenants in common or joint tenants with right of survivorship. And that brings us now to what we touched on but did not finish when it comes to life estates and remainder interests. Join me now in that discussion, which you can find here in your text. If you've got the paper version, then you are on page 346 and 347. Remainder interests, including vested remainders, were not able to qualify for the homestead creditor exemption even if he or she lived on the property, because there was no present right to possession back in the year 1969. But now we have established through amendments to Florida's Constitution and interpretations of those amendments that even a mere life estate, so long as it is a present possessory life estate interest, even a mere life estate can qualify as homestead. Now, with that said, can I pass my life estate on to my heirs? Well, of course not. If we know the definition of life estate, we know that at the end of our life estate ends. So I don't have a possessory interest to pass on to heirs if my possessory interest is a life estate. But when it comes to being divested forcibly by a creditor, we do have homestead protection despite the fact that our only ownership interest is that of a present possessory life estate. So there can't be a forced sale by most creditors. We can protect the life estate using homestead. Now, the exceptions we talked about in our last lecture apply here with equal force. So as you know, if you give a purchase money interest, such as a mortgage, to get your life estate, you can't just say, I'm not going to pay the mortgage. If you say that, you can lose the life estate and be foreclosed upon. Likewise, if you do work that results in a proper mechanics lien or construction lien upon the life estate real property, those creditors can force a sale. So you know those exceptions already. I won't burden you by going over them all yet again. I just wanted to remind you that they apply here also. We also talked about remainderment in Florida. And you remember that in Florida, unlike many other states, we can't be liable to the remainderment for waste if we properly draft the life estate. That's what gave great value to Florida's version of the enhanced life estate deed, colloquially called the Ladybird deed. And that's why it's a popular use here in Florida in life estate, enhanced life estate, Ladybird deeds, in creating estate plans. Whereas in other states, it might not be as popular. Because in other states, you'd be creating the potential liability to the remainderment. Here in Florida, if you draft the enhanced life estate deed correctly, then that quote-unquote Ladybird deed creates no actionable right to the remainderment to sue for waste. So that's what makes that a popular part of homestead. Now, let's look at a case. This is the case of Quiroga versus Citizens Property Insurance. Where are my lead counsel? Who is it that wants to cover this case? You've raised your hand. You're brave because you know how brutal I am to people in the audience. Good, you laughed. I hope I'm not brutal. All right. And your name, please. What can I call you? Corina. Corina. Yes. Corina, it's great to meet you. I'm Patrick. And this is Quiroga versus Citizens Property Insurance. What the deal, yo?
So this is an appeal from the court denied a law firm, which was Tasman Law, from getting proceeds for damages caused by 2 hurricanes.
Wait a minute. The court denied attorney fees to one of our fellow lawyers? I'm listening, aren't you? Go on.
A motion to press charging lien on the homeowner's insurance proceeds from damages caused by 2 hurricanes.
Oh, I like that, a charging lien. And we all understand what that is, right? That's what one of our fellow lawyers, or maybe even you and I, might have on the proceeds of a particular case. Imagine, if you will, that you've worked on a case on a contingency basis. I don't often do that myself. Many lawyers, that's all they do. Some lawyers dabble in it. You'll make that choice when you have your practice. But a contingency case, of course, means that you will get a percentage of the recovery, assuming there is a recovery. Was there recovery in Quiroga? Yes, there was. Was there a contingency contract in Quiroga?
Yes.
Yes, there was. Sounds like the lawyer is entitled to some money, right? Why didn't the lawyer get the money? Why did they have to file a court action?
Because the policy owner, the insured, terminated the law firm's contingency and sought to shield himself from responsibility from the compensation that he was going to receive from the insurance company.
You are correct, and beautifully correct, because you speak in the technically correct terms. I understood you. I'm sure everybody else did. So forgive me as I dumb it down. Homeowner hired lawyer and signed the contingency contract. Lawyer got the contingency. It was a windstorm claim. They'd blown off the roof, I guess it was. So the insurance company, after the lawyer got involved, coughed up full policy limits. And the lawyer called up. This part I embellish a little bit. Hey, client, good news. We got all the money you can get. We got the full policy limits. Oh, that sounds great, says client. Good, good. I'm going to keep my 33 and a third. I'm going to send you the rest. Oh, that part doesn't sound so great, says client. Well, what do you mean? Says lawyer. That's our contingency contract. Oh, yeah, sure. Well, that's my homestead, says client. Send me 100%, says client. And again, that was my ode to Walt Disney. Again, I'm working on my Goofy, the character Goofy, my Goofy impersonator. How am I doing? Am I goofy enough for him? Goofy could use some work. Goofy could use some work. All right. All right. But we both tell the same story, do we not?
Yeah.
Who should tell the ending, you or me?
I guess I should.
Go for it. All right. I'm rooting for the lawyer, by the way. Who else rooting for the lawyer? Raise your hand. Yeah. Stick up for our fellow lawyers. Yeah, go ahead.
The court affirms the lower court's order, the appellate court affirms the lower court's order
That's not sounding good for us that are rooting for the lawyers. Tell me more.
denying the motions when pressed in charging lien.
What? Wait. I'm rooting for the lawyers. Not sounding good. Go on, but give me some good news, would you? You want to, I can tell.
Yeah,
Yeah. But there isn't, is there?
no.
No, there's not.
Because,
No, there's not. Go on.
the policy owner, which is the insured
Yeah.
Nova, should be exempted from the forced sale under process of any court. They said that,
And that's black letter law homestead, right?
right,
Protection from forced sale by process of any court. Yeah, okay. So far
yeah.
sounds like the court's getting it right, but of course I'm rooting for lawyers. So go on. Tell me how lawyer wins. Does lawyer win? I want lawyer to win. Tell me how lawyer wins.
They said except for the payment of taxes, assessments thereon, obligations contracted for purchase, improvement or repair thereof, or obligations contracted for house, labor performed.
Yeah.
Yes.
Let's break that down, would you? Again, technically correct, but if you don't mind starting from the top. First item mentioned was homestead can't be sold forcibly to pay a creditor, but there's some creditors that can. The first was taxes, right? So is the law firm's contingency fee a tax? No, of course not. What was the next item on your list?
I'm sorry, you mentioned taxes,
Yeah, what's after tax?
obligations contracted for the purchase.
Obligations contracted, right? I got a contract here. The lawyer has a contingency contract. Obligations contracted for the purchase. No, this was for bringing an insurance claim from the windstorm. Nope. Okay, what's the next one?
Improvements or repair thereof.
Oh, improvements or repair thereof. Huh? How about that? Bear with me now. Okay, we got a windstorm, right? Blew off the roof, right? Homeowner wants to have a roof, right? So if you used to have a roof and the windstorm blew off your roof, then you've got to do what? Repair it, right? Oh, hey, is that it? Is that how lawyer wins? Yeah, okay. So lawyer was getting the insurance money, which in turn would be used to repair the roof. He just wanted his 33 1/3 of that money. So if it's that exception, does it? You're breaking my heart here. No, it does not. Every word you've said has been 100% correct, including that one. No, it does not. It does not meet that exception. So the ruling from Florida's 3rd District Court of Appeal in 2010, in the case of Quiroga versus Citizens Property Insurance, is homeowner got the full proceeds. Lawyer got nothing. Homeowner got the full proceeds. Lawyer got nothing. But look at the facts and how we got to this result. First of all, was that equitable? Was that fair? Was the court acting in equity? Stated somewhat differently, pretend you're me defending your fellow lawyer. You're on the side of the lawyer. Defendinglawyers.com. That's my website. You know which side I'm on? From the side of the lawyer. Was equity done? Lawyer said, I'm going to give of my time, talent, and treasure. I'm going to fight the insurance company on your behalf. Before this happens, I'm going to present you with a contingency contract that meets all the requirements of the rules regulating the Florida bar, that you deem fair, that you signed, that you willingly signed, and in reliance upon that contract, I won. I got the contingency. I got the money. The contract says I get 1/3 of it. You agreed I get 1/3 of it. Now you say I get none of it. And now the court says I get none of it. Was that equitable? Was that an equity result from the perspective of the lawyer? Clearly not. Takeaway number 1 from Quiroga versus Citizens Property Insurance. when it comes to adjudicating homestead claims, a court is not sitting in equity, and a court is not attempting to reach an equitable result. That's takeaway number one. Let's look at the next part, okay? As we went down the list of exceptions, and the black letter law exceptions, no fancy exceptions applying to a lawyer here. So even though this is a lawyer case, we're talking about the exceptions that apply to any case, right? First, we looked at taxes. Was a contingency contract to hire a lawyer a form of taxes? No, obviously not. We went down the list, we looked at that, and one of them sounded really close. Do you remember? One of them sounded really close. I was even able to articulate an argument for how it might qualify for that one. Do you remember? The one about repair or improvement to the home. It's always been true. If there's a valid construction lien from a handyman or other type of construction company or service person or handywoman or anyone who's providing repair or construction to the homestead, that's an exception. And we want that. We don't want homeowners saying, oh, yeah, go ahead and build me a fence. Yeah, go ahead and paint my house. Yeah, go ahead and put on a new roof. Pay you? No, I'm not going to pay you. Go away. We don't want that. Now, the lawyer could have, and certainly I just did, made a colorable argument about how the lawyer's fee could have fit within that exception, right? Did the court accept that presumed argument? No. So that's takeaway number 2 from Quiroga versus Citizens Property Insurance. We interpret the homestead protection from creditors as liberally as possible with the goal of achieving the result that the homesteader and the homestead are protected from the creditor. That's takeaway number 2. It was so close to that exception, was it not? A court sitting in equity could say it's close enough. But takeaway number 1 was we're not sitting in equity. And takeaway number 2 is we're going to interpret the homestead protection from creditors liberally so as to attempt to afford protection to the homesteader and the homestead. Takeaway number 3 is the one I struggle with. Why are lawyers doing windstorm claims on a contingency basis? Why are Florida lawyers doing hurricane claims, windstorm claims, hail claims, rain and wind claims, any sort of claim where the client could say, homestead, even though they signed the contingency contract? Why are they doing it? I don't have an answer. I don't have an answer for that takeaway. I have more questions from that takeaway. How about this? I love teaching ethics and professional responsibility. I love defending my fellow lawyers against bar grievances and ethics complaints. I ask, and I do not know. I ask, is there an ethical obligation to inform your client that they can stiff you on this contract? I ask, but I do not know. There are many questions I have from this third takeaway, but not a lot of answers for you. Excellent job covering this case. Thank you very much. Sorry I interrupted you constantly.
No, it's fine.
It was nothing personal. I interrupted everyone constantly. Like most lawyers, I love to hear myself speak. Taxation and finance. It's our next chapter. It's somewhat unrelated to homestead, but I can segue to it because you remember when I started the homestead lecture last class, one of the things I noted was that there was protection from creditors for the family home. Another thing I noted was there was protection for up to $1,000 in personal property. And another thing I noted was that the homestead creates a possible exemption from some property taxes levied by counties and cities and taxing authorities in Florida. So I'll circle back to that point, and that'll be my segue to taxation of finance altogether. So as I segue, jump around with me now in the book, jump around a little bit, but you can handle it. Go back to the beginning of chapter 11, which was our homestead exemption. Look at subsection B, which is on page 330 if you've got the paper version. Homestead protection from full taxation. What we talk about here is that we pay property tax based on the just value. That's a legal term of art. Just value. J-U-S-T, probably meaning fair, not only. V-A-L-U-E, value, just value. So that's how we compute the property tax. A constitutionally elected officer who has a constitutional office under Florida's Constitution is your county property appraiser. She or he is responsible for determining that just value of all real property within that county, including your homestead, if that's where your county is. But if you have filed the proper paperwork to apply for a homestead exemption and you are approved, then we subtract $25,000 from the just value before we multiply by the millage, which is rate. More on millage to come. The bottom line is this: if you qualify for this exemption, you pay less, $25,000 in value, in just value, less than the full value of the property. But wait, there's more. There's Save Our Homes. There's a percentage cap increase per year. That is all covered at the end of chapter 12. So we better get started on chapter 12, shall we? And chapter 12 has that theme. Chapter 12 says, you can't tax me like that here in Florida. And as I mentioned in the beginning, I'll mention it again because I think it's beautiful. In our Declaration of Rights, Article 1 of Florida's Constitution, among those rights are rights regarding taxation. Let's take a specific look at that. We're talking about Article 1 of Florida's Constitution, subsection 25. It requires that there be a taxpayer's bill of rights. Quote, by general law, the legislature shall prescribe and adopt a taxpayer's bill of rights that, in clear and concise language, sets forth taxpayers' rights and responsibilities and government's rights and responsibilities to deal fairly with taxpayers under the laws of this state. So what's in this taxpayer's bill of rights from Article 1, Section 25 of the Constitution? What is covered by these rights and responsibilities of the taxpayer and government's responsibility to deal fairly with the taxpayer? What's covered there are things like this. We've got a right to request assistance from a taxpayer's rights advocate who may issue a stay order against the Florida Department of Revenue. Wow. As a lawyer, I'd prefer you hire me. But it's nice that you don't have to hire a lawyer, right? We've got the taxpayer's rights advocate on the state payroll who might be able to help the taxpayer here in Florida. Another right, the right to be represented or advised by counsel. Yeah, fellow lawyers unite. Employment. You want to be employed, right? Am I the only lawyer in the room that wants to be employed? Also, the right to have the taxpayer's tax information kept confidential unless otherwise specified by law. Does the Constitution of the United States, in the text of the U.S. Constitution, create a right to financial privacy? No. As we stand here today, November 3rd, 2021, has the Supreme Court of the United States, through any case law precedent, created any U.S. constitutional right to financial privacy? No. Are there U.S. laws, U.S. code that talk about how banks can't just put your bank balance on a billboard and have to maintain some sort of privacy? Well, yes, of course. but it has not been elevated to a constitutional right. In cases such as Winfield versus Department of Parimutuel from the Supreme Court of the United States, and in laws such as the Taxpayers' Bill of Rights, as you see quoted right here, a Floridian has a financial right to privacy under the Constitution of the state of Florida. And since there is no such right to privacy under the United States Constitution, you might argue, as I often do, that a Floridian has a greater constitutional right to financial privacy than Americans do as a whole. Perhaps this is an example of that laboratory of democracy at work. Perhaps this is a greater right enjoyed by Floridians than Americans as a whole might enjoy under the US Constitution. What kind of taxes exist in Florida? Man, oh man, oh man, do we have plenty of those? Where am I in the text so that you can follow along with me here? I am, because these slides, they go fast and crazy. I want you to have some reference here. Okay, I am on page 359. Notes 2 and 3. Note 1 talked about that Taxpayers' Bill of Rights under notes and questions to consider. Now I take much from the rest of these notes and questions to consider. In note 2, I talk about the power of ad valorem taxation. What is meant by ad valorem? I cite to Smith versus American Airlines, a 1992 decision from the Supreme Court of the state of Florida that says the term means a tax imposed on the value of property. The court notes that the most common ad valorem tax is that imposed by states, counties, and cities upon real estate property taxes. But that's not the only type of ad valorem taxation we face here as Floridians. The definition does not end there, but goes on to add that ad valorem taxes can, however, be imposed upon personal property, and to some extent that has been done here in Florida. So what is ad valorem taxation? It is a tax upon the value of property. It's computed using a millage. Remember, I made a quick reference to that earlier and said there was more to come. Here's the more. I kept that promise anyway. What is a millage? A mill is the cost per 1,000 in value. So the millage represents the cost per 1,000. So that's what a mill is. We tax using a millage. It's like a percentage, but per cent, C-E-N-T, is different than per mill, M-I-L-L. Mill refers to 1,000, cent refers to 100, right? So you can think of it as tenths of a cent if you're one of these mathematicians out there. But I didn't go to math school, I went to law school. So I'm going to talk about millage. Is my goofy voice getting any better? A little bit. Thank you. I'm working on it. Another type of tax is the estate tax. That's also covered here. Now we're on page 360, note 5. What's the estate tax? Well, if you've ever had a loved one or even a friend pass away, perhaps they outlived their money, or they had assets at the time that they passed away. Society has to do something with those assets and that money. Maybe the person who passed away had an estate plan and bequeathed those assets or that money to others. Or maybe not. Maybe they died intestate, a vocabulary word we covered in our last class meeting, without any sort of written, formal, enforceable will or estate plan. Either way, we've got assets changing hands. What typically do governments do when assets change hands? They make you pay for that, right? That's an easy time to hit someone with a tax. And indeed, there is an estate tax. Now, what I'm talking about with the estate tax is different from the income tax of the estate. If you leave the estate open long enough, it might earn some interest on the money in the bank account. It might have an asset appreciate in value. The estate, just like us humans, might earn some income. If that's true, then there's a federal income tax to be paid. That could be called the estate income tax, but that should not be referred to as the estate tax. When we refer to the estate tax, we're not talking about an income tax. We're talking about a tax on the fact that we're transferring the asset from the hands of the deceased or the deceased estate to the beneficiaries or the heirs. Right now, there is a federal estate tax, and it could be in flux. The government brings in somewhere between $3 and $4 trillion a year in all kinds of federal taxes. And currently, as I stand here today in November 3rd of 2021, the government is proposing just 2 laws that are going to spend somewhere between $4 and $7 trillion. So in other words, they're going to spend every dime that comes in and then some. How do you do that? We don't know yet because they haven't passed this law, but floating around is potentially lowering the cap or the application of the federal estate tax so that even smaller estates would be subject to an estate tax. Right now, only the largest of estates are subject to a federal estate tax. But as we talk about the Constitution of the state of Florida, we must ask, what about the Constitution of Florida? What about Florida law? Is there an estate tax? And to a limited extent, there is. The first thing to note is that if your estate is not big enough to be taxed under the federal estate tax, then likewise, your estate is not taxed under the Florida estate tax. So Florida has tied its state law to federal law, referencing it directly. As federal law changes, if it changes, and if we're going to spend every single dime we bring in and then some, I guess it's going to have to change. I personally, as a head of household, I don't think it's a good idea for my household to spend every single dime we bring in and then some. But hey, who am I? I'm just a responsible individual. But so that could happen on the federal level, at which time the federal estate tax will change. And because of the way Florida's law is written, it too will change. There won't be any action needed by the legislature or any state agency here in Florida. It will simply change because it's already tied in that way. But you get a deduction. So the Florida estate tax deduction for estate taxes paid by the estate to the federal government and to other states, that's a deduction that you take off the Florida estate tax. Maybe I could explain that better. Imagine, if you will, that there is an estate and it is subject to the federal estate tax. That would mean it's also subject to the Florida estate tax. But for every penny that estate pays to the federal government for the federal estate tax, that estate gets every cent, every dollar, every bit of the federal estate tax paid as a deduction off the top of what it pays to the state of Florida for its estate tax. Perhaps the estate has some assets that are subject to the taxes of other states. Again, every cent, every amount, every dollar paid to those other states under their estate tax is 100% deducted from the amount of Florida's estate tax. So that's what I'm trying to express in this sentence. In Florida probate, the personal representative, that's what we call our executor or executrix in a Florida probate matter, the personal representative must file an affidavit before the probate judge will enter an order of discharge in a full administration, and that affidavit must state whether or not this estate was subject to the estate tax, and if so, then it must state under penalties of perjury that the estate taxes were fully paid. Only once that affidavit is signed, notarized, sealed, and filed with the court will the Florida probate court entertain a motion for entry of an order of discharge of the personal representative in a full administration in Florida probate. Question? Yes.
So maybe I have another thing, but so it sounds like you're saying that, So let's just say on federal, you owe $1,000 in a state tax. I'm trying to do easy math here.
Okay, I like easy math, because that's about all the math I can handle. All right, so hypothetically, to the feds, we owe $1,000 on an estate tax.
And then just say Georgia, you owe $100, an additional, you have property or something, another state, $100.
And to continue the hypothetical, you owe another state $100 on its estate tax for that state.
Correct. So you paid out $1,100.
Paid full, $1,100.
And then in Florida, if you owe more than $1,100, you would still owe the remainder.
Correct. Did everybody get that? It was well said. So in the hypothetical we just had, you owed the federales $1,000 on the estate tax. You owed other state, not Florida, $100 on its estate tax, and you owed Florida $1,101. First, you subtract $1,000 for what you paid the federales. Then you subtract $100 for what you paid the out-of-state other state. Now you owe $1. It's the state of Florida.
And then if you owe.
And those are hypothetical numbers, but that shows how it works. That's the correct way of
So if you
showing
only
how
owe
it works.
$900 in Florida to begin with,
Okay,
that doesn't matter, you still have.
making the math harder now. Okay, so I still owe $1,000 and pay $1,000 to the federal government on federal state tax. I still owe $100, pay $100 to some other state other than Florida on that other state's state tax. The calculation in Florida is that I would owe $900 on the state tax. Now I pay Florida $0.00. Because I had $900 owed to Florida, but I had a deduction for $1,100. So the deduction ate up the entire Florida estate tax bill, leaving me with $0 on my Florida estate tax bill in that hypothetical. Yeah, you do have it. And does everybody else have it? We all got it? Gotta stay awake for the tax lecture. Their entire law school class is in tax. Yeah, there are. But not this one, not this one. We're going to get through this, people. Stay with me now. All right. That's not all the types of taxes we have in Florida. The gross receipts tax. Now we're on page 361. If you've got the paper version, we're in notes and questions to consider note number 6 if you've got an electronic version. Gross receipt taxes may be enacted by Florida's legislature despite the Florida Constitution restriction against personal income taxes. Oh, that was a huge one. I remember mentioning that, other than in the very opening of the class. I mentioned in the very opening, first few words that came out of my mouth after I apologized for the technical problems, that Florida does not have a state income tax. That's worth repeating. And by reading that sentence just there, I did repeat it. But that's certainly worth knowing, is it not? That's huge when it comes to comparing Florida to the 50 other states in the District of Columbia and our territories such as Puerto Rico and Guam. Not all of those can say what Florida can say when Florida says. No income tax here in the state of Florida, right? That's huge. That's huge. But a gross receipts tax is allowed in Florida, and it happens in Florida, despite the fact that we've enshrined in our Constitution a restriction that forbids the Florida legislature or the Board of County Commissioners or the City Council or any other taxing authority from imposing an income tax upon Floridians. They're not allowed to do that, but they are allowed to do gross receipts. A gross receipts tax, it's unlike a sales tax. We're all familiar with sales tax, right? Because we all buy things. Buy something for $1, you bring it to the cash register. How much do you owe? $1.06 some places, $1.07 in other places, $1.08 in some other places, right? Because you've got the local option sales tax. I'll be covering that also in greater detail. But the gross receipts tax is not the same as the sales tax, or to state it more technically correct, in Florida, the sales and use tax, because our sales tax applies even when there's not a sale. So in Florida, it's a sales and use tax. The gross receipts tax is unlike the sales and use tax. Sales and use tax is imposed upon buyers. A gross receipts tax is imposed upon and collected from sellers. So that's how it differs. I can summarize that closer here to say it's imposed upon sellers, not buyers. The next bullet I would say is that it's only upon enumerated categories, not all things. So unless and until somebody puts it on the enumerated list as subject to the gross receipts tax, the seller is not paying the gross receipts tax and doesn't owe it unless it's on the enumerated list. It's not a violation of Florida's Constitution's restriction against personal income taxes. Supreme Court of the United States has reared its head into this area of state taxation. Can the Supreme Court of the United States make a binding case law decision that would affect state taxation? After all, we're talking about a state's constitution. We're talking about the Constitution of the state, not of the United States. We're talking about a state's statutes. We're talking about the statutes of a state, not of the United States. But you know the Supremacy Clause. You know that under the Constitution of the United States, the laws of the United States that are constitutional prevail and preempt over any state law to the contrary, even a state constitution, right? So we've got to worry about what SCOTUS has said when it comes to gross receipts tax, even though it's an issue of federal law, not of state law. Supreme Court of the United States requires 1, a substantial nexus, 2, not multiple, 3, not discriminatory, and 4, fairly related. I'm not going to turn our state con law class into a federal con law class, other than to cover federalism so that you understand it. And this is the standard that SCOTUS requires, Supreme Court of the United States requires when it comes to a state excise tax. When it comes to a state gross receipts tax like we have here in the state of Florida. What's an example of something in Florida that's subject to the gross receipts tax? Well, how about gross sales of a utility? Those are subject. So when it comes to utility bills, they could be lower if we weren't subjecting the utility to a gross receipts tax. And ultimately, that's the message that those who advocate for responsible taxation are quick to remind us of. Even if we are not the one from whom the tax is initially imposed, we, the consumer, we, the head of household, we, the family woman or family man, might ultimately be the person who pays the price for that tax. That can certainly be true with the gross receipts tax. Yes, it's imposed upon the sellers. Yes, it's imposed upon the utility. But utilities are entitled to a fair profit under Florida law. They could get that fair profit at a lower price if they weren't also paying a gross receipts tax. Isn't that right? Which would mean what? The prices would go down. Which would mean what? You and I, as the head of household, as the family woman, as the family man, as the breadwinner, wouldn't need so much bread to win because the utility bill would be lower. And if the cost of utilities is lower, what else is lower? Anything and everything you need to make using utilities. And what is it that you can make without a utility? I mean, what service can you provide without a utility? Got to have utilities, right? I think it's all a question. Yes.
So, in case of utilities like electric,
Yeah, that's a good example.
is it on the producers or simply on the sellers to the end thing?
No, it's going to be on the producer.
Okay.
Yeah.
So it's on like Duke produces it, but then sells it to the city of Orlando, who then sells it to me.
The producer paid it.
Okay.
Yes. Everybody got that? Okay. Another type of tax is the excise tax. And I know you want to keep up in the book. Now we're on page 362 toward the bottom. It's note in question, consider number 7 if you've got an electronic version. An excise tax is any tax that does not fall within the classification of a poll tax or a property tax, and that embraces every form of burden not laid directly upon persons or property. Unlike sales tax that apply to all items not exempted, excise taxes apply only to enumerated items, Whereas sales taxes are computed always as a percentage of the purchase price, excise taxes are computed either on a per unit basis or as a percentage of the purchase price. So the excise tax is not imposed directly upon persons or property. Not directly. Not directly. The excise tax is only upon enumerated items. And it's not uniform from type or class of item to type or class of item. The excise tax is computed per unit or a percentage of the purchase price. The excise tax, you'll see that different taxing authorities use different values. So one good, you would think, would have a uniform value, but different taxing authorities will use different values for that same good when imposing an excise tax. An example, tax upon purchase of electricity. Okay, now this is the tax you see on your tax bill. We're now talking about the consumer who turns on the lights, and because they turned on the lights, got a tax bill and got an electric bill in the mail because they turned on the lights. And within that electric bill are some taxes, excise taxes to be exact, and the Florida dock stamp tax. If you practice real property law in Florida, you will note that our taxes upon real property transactions might be higher than some other states, certainly more prevalent than any other state. If you're filing a document that has to do with real property, which often you'll do if you're doing an estate plan, for example, you're going to pay a minimum of 70 cents for your dock stamp. You'll pay much more than that minimum if the value is over $10. For example, if there is a mortgage to be recorded, you might be doing a mortgage for $100,000, $500,000. Someone might take out a mortgage for $3 million. I don't know what kind of house they want to buy, but you're going to pay a lot of money in dock stamps that go up and up and up based on the value. That's a type of excise tax that's quite prevalent here in the state of Florida and is a major source of Florida income for the government here in Florida. Sales and use tax. And I warned you, when we're talking about Florida's sales tax, there doesn't have to be a sale. For that reason, it's technically inaccurate to call Florida's sales tax. It's far more accurate to call it the sales and use tax. Here now we're up to page 363. This is note and question to consider number 8. Sales and use taxes are imposed by Florida's legislature plus a local option. Local option sales taxes are a surtax that increase Florida's sales tax on a regional basis, thereby making the sales tax rate vary throughout the state. So sales and use tax are imposed statewide, plus that local option. McGinley, what's covered by the sales and use tax? Oh, there's so much. Let me see if I can give you some examples. See what I got. There's a discretionary sales tax. That's that local option. Sometimes it's called a half penny sales tax. Sometimes it's a full penny. I think maybe there might be a penny and a half floating around here somewhere. And when you phrase it that way, oh, it's just a penny. Oh, hey, it's just a hay penny. And if you haven't got a hay penny, God bless you. Right? It sounds like just a thing that doesn't matter. But we're talking about per dollar. We're talking about a penny per dollar. That adds up quickly for our fellow Floridians. So the local use or the local option, this discretionary sales tax, it's a euphemism to call it a penny or half penny tax because you're paying a lot more than a half penny or a penny by the time it's the end of the month. And we all know fellow Floridians, maybe we've been one of them or we are one of them, where that Floridian runs out of money before that Floridian runs out of month, you know? So let's drop the euphemisms. It's It's more than just a half penny or a penny. It adds up quickly. Fuel taxes. Need to get anywhere? You can't appear by Zoom everywhere, right? Sometimes you got to be somewhere. Sometimes you just want to be somewhere. For most people, that involves buying and consuming some fuel. Fuel tax is subject to sales and use tax. Transient rental taxes. Let me put it that way. Oh, there's some transients around here. Let's slap them with a tax. We're talking about hotel rooms, right? We're talking about vacation. Maybe you're working for a living for work. No, you're living for that vacation. Maybe you only get a week off. We're increasing the price of your hotel room by the sales and use tax. Maybe you've got beach house. You're not using it 24/7. You're going to put it on the Vrbo or on the Airbnb or whatever website helps you rent it out to perfect strangers. You got to keep track of the transient rental taxes on top of the other taxes and remit them properly. Tourist development taxes. Is tourism a big deal? Well, 150 years ago, a Floridian might have just said, if it doesn't have anything to do with citrus, doesn't matter. But that's not our economy today here in Florida, is it? We're a lot more than citrus, aren't we? We have a lot to do with tourism. We're making it more expensive for the tourists to come. We certainly are making it more expensive with the sales and use tax. Food and beverage taxes. And when I talk about the food and beverage tax and the tourism tax and the transient rental tax and the fuels tax, that's on top of the sales tax of 6%. That's on top of the discretionary local option, the half penny sales tax. That's making it go up. That's making it 8, 9, 10, 11, 12, 13%. What's another example? Municipal resort taxes. Okay, so the state of Florida is going to tax the tourists. The county is going to tax the tourist. And now the city's going to tax the tourist. Are we forgetting we're relying upon them for our livelihood? Tax. Convention development taxes. Oh, you want to attract tourists to your town? We'll tax you for trying to do that. Impact taxes. You brought more people to town. You succeeded. Now there's more cars on the road. I'm going to tax you for that. Gas tax. Yep. All those cars that are driving around, we're going to tax them for driving on the roads that we taxed, to go to the convention that we taxed, within the municipality that we taxed. Family office. So many of us want to work from home. Many more of us have to work from home. What if you want to have a family office? What if you're a fellow lawyer? You want to have a law firm. You want the law firm to have an office. What did you learn in business class? You create an LLC, right? And you take title to that real property, to that office in the name of the LLC, right? Because what if a customer slips and falls? What if there's some sort of liability rising out of this ownership? You create a separate corporate entity in an attempt, along with a good insurance policy, to protect yourself from that potential liability. What does the state of Florida say? Well, that LLC that owns the office, that's a legally separate person under a legal fiction. Therefore, you don't own the office. The LLC does. Therefore, you're using the office. Therefore, you owe sales and use tax. But I didn't lease it from myself. I didn't exchange any money in hands. I just created an LLC and I put them on the deed. Yes. And now once a month, every month, for the rest of your life until you die, you're paying a sales and use tax because you used your property, which under the legal fiction isn't your property, it's the LLC's property. Tax. Woo, woo. But wait, there's more. Repairs or alterations. You worked hard, you managed to buy an asset, things wear out. Now I have to scrape up the money to fix it. You got to pay the taxes on the repairs and alterations you made. Enumerated services, crime prevention services, non-residential pest control services. It's true that the sales and use tax applies to all goods and applies to all uses, in Florida, it's not true that all services are exempt from the sales and use tax. Enumerated services apply. Crime prevention services. What if you, the lawyer, were helping a client in an unpopular case? Now you need a bodyguard for a couple of days or for the rest of your life. You're paying taxes on that. What if you just own an office and you don't like palmetto bugs? For those of you who aren't Floridians, that's what we call the biggest of our roaches down here in Florida. They're huge, and some of them can fly. I'm talking an 1.5 inch long roach that can fly. We call it palmetto bug. Maybe you don't want those flying around your office while you're trying to seal the deal with opposing counsel. You might want some pest control services. You're going to pay taxes on that. Non-residential property needs some paint once in a while. Want to roll up your sleeves and paint your law office yourself? Go ahead. But if you don't, you hire someone to do it, you're paying taxes on that non-residential painting services. I'd go on, but the font got so small that I was afraid y'all couldn't read it anymore. I'd love to tell you that this is like all of it. It's not. I'd love to tell you it's even half of it. It's not. I'd love to tell you it's just 25%. It's not. Sales and use tax goes on, and on. Out-of-state businesses selling into Florida that have any number of transactions with the total sales over $100,000 in a prior calendar year. That's the current state of when the state of Florida will seek collections. But of course, there's nothing that limits state of Florida to just collecting sales and use taxes to those out-of-state businesses that sell into Florida that had transactions with total sales of $100,000 or more last year. Once the technology becomes readily available to tax those eBay or those Amazon or those Google sales, you betcha they're going to kick in. And the list goes on and on and on. So we've got ad valorem taxation. We've got estate taxes. We've got gross receipt taxes. We've got excise taxes. We've got sales and use taxes. But what don't we have? State income tax. Whew! At least we avoided one of them. I don't know, maybe we made up for it with the others. But at least we avoided one of them. So I've been ragging real hard on taxes. Who did I offend? Who here loves taxes? Who says more taxes for me? Who fills out their tax return, finds out they only owe a small amount, and sends in a larger amount anyway? Go ahead, raise your hand. Raise your hand. All right, good. I'm not talking to anybody who's doing that. Which of these would be the most egregious? It's just a matter of opinion. Where's my lead counsel? What's your opinion? What would be the most egregious? If you had to pick the biggest evil on the list of taxes. And I know some people don't see taxes as evil. I respect that. But play devil's advocate, if you will. Pick one of these demons as the worst of the demons. Which is the worst demon? It's a matter of opinion. You can't get it wrong. I'm going to go with the ad valorem taxation. I'm going to go with that one. In a way, for so long as the asset is subject to ad valorem taxation and the enforcement mechanism is to confiscate or foreclose upon the asset, then in a way, do you ever really own that asset? Think about it. Do you ever really own that asset? For example, property tax. That's a type of ad valorem taxation. Okay? Say you scrape and you save. For most people, that means a down payment. If you're particularly blessed, maybe that means buying the property in cash. But for so many Americans, the scraping and the saving to become a homeowner means the down payment, right? So whether you just made a down payment or whether you paid cash, let's pretend you paid cash, all right? You have no mortgage. Does that mean you have no bill? No, you still get the property tax bill. And even though you pay cash, even though you got no mortgage, what happens if you don't pay a property tax bill? You lose the property. Now, I know we say we own our homes. I own my house. But if you really think about it, if it's only yours tentatively, so long as you keep paying the bill, a bill which almost invariably goes up every year, do you really own it? Well, if I say to you, I'm gonna give you this pencil, okay? But you're gonna give me $1 every month. And and that'll go up from over time. And the first time you miss a payment, I get my pencil back. Do you really feel like you own my pencil? So that's who I'd pick as the biggest villain. I'd pick ad valorem taxation. That's what I'd pick. Another reason I'd make that the biggest villain. Say I invest in something that's not subject to ad valorem taxation, okay? And its value goes up. I don't owe a tax based on the fact that its value went up. But if I invest in something subject to ad valorem taxation and its value goes up on paper, nobody sent me a check, its value went up on paper. Now I got to mail a check. To help you understand what I'm saying there, say you're blessed. You've got $100,000 to invest. You might buy a 1-bedroom condo in a modest building, or you might put it in an IRA, invest in some stocks. Now, either way, hopefully, whichever investment you chose, its value goes up. Maybe you look on paper, hey, my IRA is now worth $110,000, okay? But you didn't get any money. You didn't receive any income. What's your tax bill? It's zero, right? Because all you owed on that was income tax. But what if instead you invested that money in real property, in real estate? Now you don't owe just income tax. You also owe ad valorem tax. Property went up to $110,000, so your bill goes up. You didn't get any money out of the property. The real property, that nice 1-bedroom condo you invested in, didn't create any income, but you still have a tax bill to pay. So you got a bill to pay without any money to pay it with. That's another one of the evils of ad valorem taxation, in my humble opinion. And I respect the fact that many of you love taxes. You fill out your tax return, you see you only owe $20, and you send in $200 because you love taxes. You want your taxes to be higher. You want everyone's taxes to be higher. I understand that's some of your opinions. I don't agree, but I respect that we have different opinions. So there you go. Let's take our break. When we do, let's look at some case law precedent that's going to show us even more ways in Florida for Florida's governments to take our money forcibly, to even add that debt to our tax bill, to subject to us to foreclosure or forfeiture if we don't pay it, but that don't count as taxes. Those aren't taxes, folks. It's just more money you got to pay. It's on your tax bill too, but it's not a tax. And we'll cover those after our break. Let's take 6 minutes. Sound good? See you in 6. I'm looking for Kevin, Keena, and Jay. Oh, hey, how you doing? How's the written outline coming? I'm sorry, I didn't see it. Okay. Patrick at McKinley Law. Yeah. That's the right place. Okay, all right. I left for class 4:45. Maybe it was after that? Okay. No, if you emailed it, that's cool. I haven't checked emails since 4:45. In fact, I can do that on the phone. Hold on. I want to make sure to get it to everybody. I know how hard y'all worked on it. And I want to get it on the website, so yeah. Yeah, 5:05 p.m. Okay, crossed in the mail, so to speak. I'll at the office at 4:45. Okay, all right. So everybody who sort of heard that conversation or whoever didn't, I want to thank our lead counsels who are our authors this week, Kevin, Keena, and Jay. I left the office at 4:45 to get here for the lecture. They sent me the email at 5 o'clock. For that reason, I haven't posted the results of their hard work on the class website yet, flaconstitution.com, but of course I will. And I haven't seen what they've done yet, but I got no doubts that it looks good. It looks good? It looks good. It looks good. We got votes for looks good, right? All right, we got 3 votes for looks good. So round of applause then for their hard work. All right, I appreciate that. And Karina, you're knocking it out of the park. Hands for Karina. All right. For anybody else who's daring enough to speak and I didn't applaud for earlier in the semester, my hat's off to you. But see, it's not easy. It's not easy, right? You know, I'm nervous every minute that I'm standing up here, especially when I'm praying. I didn't grow up praying out loud. That wasn't part of my family. So it took me some time to get the guts to not only speak in front of a crowd, but to pray in front of one. So You're a lawyer, you'll certainly have to speak in front of a crowd at some point, whether it's in a negotiation, in a courtroom, in an agency, or whatever. So you know what I'm talking about. It can be nerve-wracking. So hats off to not only our author lead counsels, but to our speaker lead counsels too. So hats off to all of you. All right, so thank you for keeping the break brief. There's a monitor up here for me to use, but it doesn't work. No surprise, right? So I gotta see what's going on up here. Okay. I don't know which one of y'all is not paying your tuition. And that's why all this equipment's falling apart, but all right. So just a quick thing I wanted to cover, if you can see it. I'm so sorry about the glare from the lights in this room. I can't move the monitor much more because the wire is as long as it goes. But I wanted to cover who's liable for taxes, who pays these taxes to the extent of governments. Because, we've covered the fact that there's not just the state of Florida, there's also 67 counties, each of which either has home rule from a constitutional standpoint because it's a charter county, or it has home rule from the Municipal Home Rule Powers Act enacted by Florida's legislature to try to give comparable home rule power, statutory home rule power, to the non-charter counties. So we've got counties, we also have municipalities. Any piece of land might incorporate and call itself a city or a town or village or the villages. We've got a town in Florida called the Villages. So these entities have lawmaking rights. They also have the rights, whether they're a county or a city or an entity of that nature, to own property, whether it's real or personal property. So are they paying these taxes? That's what I wanted to cover real quick. Does the state of Florida, its agencies, its counties, and its municipal corporations pay taxes to the state of Florida? So we're not answering a federal question, right? I'm answering a state taxation question. These agencies, these counties, these municipal corporations, are they paying the taxes we looked at a moment ago? That's the question. Here's the answer broken down. First, the state and its counties are immune from taxation. That is part of their sovereign immunity. We've already discussed in greater detail sovereign immunity. So this is a reminder when it comes to these excise, state sales and use taxes, all these different taxes we talked about earlier in this lecture. The state and its counties are immune from that taxation. Unlike counties, municipalities are not subdivisions of the state and therefore are subject to taxation absent an exemption. So if I'm the state itself, I have sovereign immunity. If I'm county, I'm a subdivision of the state. I enjoy that sovereign immunity from taxation. Not so for cities, towns, villages, the villages. They need to find themselves an exemption. Without one, they owe the tax. Article 7, Section 3A of Florida's Constitution confers upon property owned by municipalities an exemption from ad valorem taxation if owned by a municipality and used exclusively for public purposes. So for a municipality that is seeking an exemption, here's one. It can cite to Florida's Constitution, Article 7, Section 3A. There, if the municipality owns property, they're going to get an exemption from at least one form of taxation, that's ad valorem taxation, so long as that municipality is using that property exclusively for public purposes. So that is an issue I wanted to cover real quick. That's the answer to that issue. Any questions about that issue before we take a look at the case law like I promised to do? Got some fun and exciting cases. And hopefully I edited them well, because who wants to read a long tax decision, right? Okay, so let's take a look. First of all right. I am not going to be upset about the equipment breakdowns in this lecture. I'm just going to embrace it. On paper, I'm on page 371. It's subsection 2 if you've got a digital format. What we're talking about are non-tax revenue sources. Non-tax revenue sources. You just saw tax after tax after tax. Oh, I got a question. Yeah. No, that was worth a shot. Yeah, because sometimes it's the battery. It could be. Let me make sure the keyboard's plugged in. That's worth a shot. As far as I can tell, the keyboard's plugged in. Thank you. Thank you. Yeah. But this is not going to bother us. It's not going to slow us down. We're still going to talk about non-tax revenue sources. What makes it a non-tax revenue source? The fact that it doesn't meet the state of Florida's definition of tax. What is that definition of tax? That's on page 371. Florida Supreme Court defines tax as follows, quote, an enforced burden imposed by sovereign right for the support of the government, the administration of law, and the exercise of various functions the sovereign is called on to perform, end quote. And I get that definition from a 1994 decision of the Supreme Court of the State of Florida called State versus City of Port Orange. Okay, so if it doesn't meet the definition of tax, does that mean they can't collect the revenue from us? Well, that would be nice, but that's not what it means. And the case law that I'll present to you now, you'll see that there are various ways they can still get our money, even though it doesn't meet the definition of tax. First case we're going to look at is Morris versus City of Cape Coral. Morris versus City of Cape Coral. Starts on page 371. It rambles a little bit, but I did edit it, I swear. It's going to go all the way to page 379. So here in Morris versus City of Cape Coral, what's going on? Well, we're worried about fire. And rightfully so. Fire can be a problem. What's the government typically do for us? They either organize volunteer firemen, firefighters, firewomen, or they employ firefighters. Either way, our firefighters deserve safety equipment. Wouldn't you agree? Whether volunteer or not. Also, they both deserve and desperately need sophisticated and expensive equipment to put out fires, whether that's a hook and ladder, whether that's a proper hose, whether that's an infrastructure of powerful fire hydrants putting out water at far more pounds per square inch than my garden hose puts out. There's a lot that has to be provided to our first responders, to our firefighters. Now, they've got a great idea over here in Morris versus City of Cape Coral. Of course, everybody's already paying that long litany of taxes that we had on the big board back when the big board used to work. But they've got another idea. We're going to levy a special assessment for those folks who would like their fires put out if they have a fire. We're going to hire fancy consulting, somebody and associates. They're going to divide in this part of our city real property into two different types. We're going to call one type Tier 1. We're going to call one type Tier 2. And these fancy consultants who are experts in who's in Tier 1 and who's in Tier 2 are going to decide which one of the properties go into Tier 1 versus Tier 2 based on what kind of needs they would have if there was a fire. Then we're going to keep the taxes right where they are, but in addition, we're going to add a special assessment to everybody's tax bill, everybody in this region. If you're in Tier 2, you're getting a hefty special assessment, but you should be thankful for that, because if you're in Tier 1, you're getting an even bigger special assessment based on the fact that somebody in associates says that you would have more needs in case of a fire than the Tier 2 property would have. Somebody files a lawsuit. I don't like this plan, says plaintiff. I'm already paying taxes. There's things you should do with my taxes, such as the health, safety, and welfare of my community, among which is to help our first responders with the infrastructure and the firefighting equipment that they need. I'm already paying taxes for firefighting services. I don't like this special assessment. So what's the court do with this? First thing we got to note is the standard of review. You find on page 373 that the court finds its standard of review to be limited. This court's scope of review is limited to 1, whether the municipality has the authority to issue the assessment, 2, whether the purpose of the assessment is legal, and 3, whether the assessment complies with the requirements of law. All right. Whew, says plaintiff. I can go to court. That's good to know, right? But is plaintiff also breathing a sigh of relief of the standard of review? Is this a lofty standard? Is this a tough standard to meet? What's your guess? What's your guess? You're guessing no? You're guessing right. Not a lofty standard to meet. Let's hear some of this standard fleshed out. Quote, a valid special assessment must meet 2 requirements. 1, the property assessed must derive a special benefit from the service provided. And 2, the assessment must be fairly and reasonably apportioned according to the benefits received. Red flag, alert. Whoop, 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 whoop. We're studying constitutional law. Whoop, whoop, whoop. We just saw the word reasonable. In constitutional law class or constitutional law issue, if the burden on the government is to be reasonable, is that a hefty burden to meet? We're talking about a rational relationship sort of standard, right? We're not talking strict scrutiny. We're not even talking intermediate scrutiny, if there is such a thing. Is there a lower standard to hold the government to than reasonable? I don't know, maybe not arbitrary. And of course, as the opinion goes on, I heard you laughing. The standard becomes whether or not the special assessment was arbitrary. Good, you're reading these cases. I appreciate that. All right, so there's our standard. These 2 prongs both constitute questions of fact for a legislative body rather than the judiciary, end quote. What's the court saying? There's a standard to meet. It's the lowest possible standard possible. And don't be bothering me with it, man. That's for the legislature. I paraphrase. But basically, that's what the court's saying, right? The standard to be applied to both prongs is that the legislative findings should be upheld unless the determination is arbitrary. Ouch! Nail in the coffin, death knell kind of holding there, man. If you're the plaintiff, right? Okay, so what happens to this special assessment? Is it struck down or is it upheld? You can guess from the standard that it's going to be upheld. And since you read the opinion, you know that that is indeed the outcome. Special assessment is upheld. It's upheld. Notes and questions to consider. Note 1, what is a special assessment and why would a municipal corporation impose one? Here's an explanation from a commentator's. This is from Stetson Law Review. Cities impose special assessments to generate revenue. Wow. Did everyone write that down? You want me to say that again? Okay, but it gets better. I quoted this Law Review article for a reason. Special assessments and ad valorem property taxes are similar, but they're not the same. For example, payment is mandatory and they're both levied on real property. The central distinction is that a special assessment must confer a specific benefit upon the land burdened by the assessment, while property taxes do not. Okay, all right. In other words, property taxes may be levied to finance general government expenses without regard to how the taxes benefit any particular property. However, with special assessments, there must be a connection between the assessed properties and the government expenses financed by the assessment revenue. A connection. Does that mean we've got to spend every dollar, every penny, and every cent? No. There's always administrative costs, especially when government gets involved. My, oh my, do they find a way to pay the most for everything and to do things inefficiently. Isn't that right? But there has to be a connection. A special assessment is validly imposed if it meets a two-pronged test. Under the special benefit prong, all the assessed parcels must receive a special benefit. Under the fair apportionment prong, the cost of the improvements must be fairly and reasonably apportioned. The question is whether the amount assessed for each property is reasonably proportional to the benefit the property receives. Again, it sounds mathematical till somebody sticks the word reasonably in there. And when it comes to something being constitutional or unconstitutional, reasonable gives every benefit of the doubt to the government, right? You learned that in Con Law 1, your rational relationship test, right? A city's legislative determinations of fair apportionment are presumptively valid, and courts must review them under a highly deferential standard. A court cannot disturb a city's legislative determination unless it is arbitrary. So right there in this quote from Susan Schurudy, Chris Rowe, Ellie Nyberger, Tyler Egbert, and Zach Lombardo, who wrote this law review article for the Stetson Law Review in 2016, volume 45. They gave us a very nice summary of the holding of the case that I presented to you, did they not? And indeed, that is the black letter law that we will apply when it comes to a special assessment. Note 2, what satisfies the first prong of the two-prong test? Remember, the first prong was the special benefit prong. So what satisfies special benefit? Prong number 1 of 2. It is satisfied when that portion of the community which is required to bear it receives some special or peculiar benefit in the enhancement of value of the property against which it is imposed as a result of the improvement made with the proceeds of the special assessment. It is limited to the property benefit, is not governed by uniformity, and may be determined legislatively. Stated somewhat differently, the property of the taxpayer must be deemed by the legislative authority, not the courts, the legislative authority, to be benefited over and beyond the general benefit to the community. Now, you can only imagine the plaintiff's argument saying any piece of property in my community can catch fire. Every piece of property in my community needs firefighters to respond to a fire. So what's the special assessment? Why was this limited to the property benefit? Why was it a special or peculiar benefit? And the reason had to do with somebody and associates. Remember at the beginning of our fact pattern, the legislative body hired somebody and associates to do their fancy report because they were experts on whether a property was a tier 1 property or whether a property was a tier 2 property. They knew with their somebody and associates expertise, for which I'm sure they were handsomely paid, which property belonged to tier 1 and which property belonged to tier 2. They wrote a very long report. I bet it was typed and it was beautiful to look at, explaining exactly why the ones they colored it on the map with the tier 1 color were tier 1s, and why the ones they colored on the map with the tier 2 color were tier 2s. What is that? That's expensive, right? That's time consuming, right? That's a big paycheck for somebody and associates, right? But what is it also? It's not arbitrary. It's not arbitrary. What is arbitrary? Have you got a coin? Flip that coin. A coin flip, that's arbitrary. What if we just draw lots? We'll put the names of all the properties in a hat. We'll pull out half. If we pull out you, you're tier 1. If we didn't pull out you, you're tier 2. That's arbitrary. But if we hire fancy somebody and associates who gives us a very detailed report, the pretty map on it, That's not arbitrary. And that's our judicial standard of review, not arbitrary. Well, but what if it's politically motivated? What if it's, I question the expertise of somebody and associates. All these things can be done. You can raise the issue of political motivation. You can question the expertise of somebody and associates. But you do that before the legislative body. Those aren't issues for the judiciary and for judicial review. Those are issues for the elected officials on the legislative body. That's what they're saying in this case. Note and question to consider number 3. What satisfies the second prong of the two-prong test? And you remember the second prong? That was the fair apportionment prong. How can it be fairly apportioned? And I've got a quote here that tells us, to be legal, special assessments must be directly proportionate to the benefits to the property upon which they are levied. And this may not be inferred from a situation where all property is assessed for the benefit of the whole. So in other words, you might not like the fact that somebody in associates is deemed to be an expert in something as obscure as whether you're a tier 1 or a tier 2 property. You might not even like the outcome of somebody in associates' report. But the fact that the legislative body took the time to divide the properties into at least 2 different tiers, that means the special assessments were not all the same. That means that particular individual parcels are particularly benefited in the ratio that the assessed value of each bears to the total value of all the property in the district. That means they satisfied prong 2. McGinley, I don't like the way this legislative thing happens. Well, good. Go talk to your elected officials. Maybe even show up at the meetings. We studied the Sunshine Law. Assuming the FBI doesn't arrest you as a domestic terrorist, you'll be able to express to your elected officials that you don't like the way they're doing things. And hopefully, either out of concern for the fact that they're a fiduciary that's been elected to represent you, or out of the selfish concern that they hope to get reelected and they'll lose your vote if they don't please you, hopefully your elected officials will do what's best for you and your community. Assuming our government allows us to continue to talk to our elected officials, which, Lord willing, we'll always have the right to do. Note 4. In Morris versus City of Cape Coral, the city lacked the power to tax its residents for fire services, yet the city created a financial liability for all property owners, Tier 1, and additional liability for owners of developed property, Tier 2, and they had to pay it as a special assessment. Florida Supreme Court held that neither Tier 1 nor Tier 2 met the definition of a tax, and that both tiers met the legal requirements for special assessment. Is this just a matter of semantics? That's the question in note 4. I offer a bit of an answer. Florida Supreme Court holds that the power of a municipality to tax should not be broadened by semantics. That's a 1994 decision of the Florida Supreme Court that we mentioned earlier, State versus City of Port Orange. Therefore, a financial liability that meets the definition of a tax cannot be levied just by labeling it as a special assessment. In Florida's Constitution, the voters have placed a limit on ad valorem millage available to municipalities, made homesteads exempt from taxation up to minimum limits, and exempted from levy those homesteads specifically eliminated in Article 10, Section 4. These constitutional provisions cannot be circumvented by creativity. So that, ladies and gentlemen, is a stronger basis for judicial review than anything raised in Morris in this case. These issues weren't raised, maybe because they were inapplicable. But in a different case, perhaps they would be applicable. And I dare say you might get a different outcome because they're a stronger basis. That's note 4. Note 7. I'm now on page 382. In lieu of a special assessment, another funding method used by Florida's governmental entities who lack the power to tax, or even those who do have the power to tax, is called a user fee. Examples include utility fees for sewer, electric, park pavilion rental fees, permits, licenses, and the like. User fees are charged based upon the proprietary right of the governing body, permitting the use of the instrumentality involved. Such fees share common traits that distinguish them from taxes. They are charged in exchange for a particular governmental service that benefits the party paying the fee in a manner not shared by other members of society. They are paid by choice. That's important. They're paid by choice. And that the party paying the fee has the option of not utilizing the governmental service and thereby avoiding the charge. Let me give you an example. My 11-year-old son, Patrick James, wasn't always 11. On his first birthday, we decided to hold his birthday party over at Azalea Lane Park, corner of Azalea Lane and Minnesota Avenue, Winter Park, because he loves going there, because it's got a great playground. It's also right next to the railroad track, and he's 1 year old. He's fascinated by the trains going by. He calls them chooch or choo-choo, depending on which one he can enunciate that day. He's just a year old. He sits on a rock in the corner of the park. The kids love to sit on that rock as the train comes by. They watch the train go, and they're fascinated by the train. They don't take their eyes off it. It's the cutest thing. So my wife Bernadette and I, we decided to have his birthday party there. But there's a pavilion. So we rented the pavilion. It was by choice. We paid the user fee, paid it to the city of Winter Park. In return, they really knocked themselves out. They printed an 8.5 by 11 piece of paper that says reserved for McGinley for whatever 2 hours it was, 3 p.m. to 5 p.m. And they put it in the existing little glass box there. There's no one around to enforce it other than me. Every now and then someone's trying to crash Patrick James's first birthday party. I had to politely tell him, I paid for the pavilion today and today only. Here's the sign from 3 to 5. Just Patrick James and his invited friends. Sorry to exclude you. But I had that right. I wanted to make Patrick James's birthday special instead of strangers crashing it. Even though it was outside at the park, he could still run with the strangers and sit on the rocks and see the train go by. He could still play in the playground. The strangers could sit on the rocks. The strangers could play in the playground. They just, for those 2 hours, had to either ask my permission for the pavilion or just stay out of the pavilion, one or the other, because I paid the user fee. And that's an example. Why can the city charge such a thing? After all, I'm paying property taxes, and in the city of Winter Park, I'm paying a hefty property tax. Believe you me, I am. And who bought the land for the park? I bet it was us people who paid property taxes. And who paid for the pavilion to get built? I bet it was us who paid property taxes. Who's paying to have the pavilion maintained? I bet it was us that paid the property taxes. But yet, if you weren't invited to Patrick James' birthday party that day, you had to stay out of the pavilion if I didn't let you in. And I'm just a private citizen. Who am I to exclude you from the city's property? Well, for that 2 hours, I guess I was Superman, because I did have the legal right to do that. That's how a user fee works. So that's what we're talking about there. And that's another example of how governments can stick us with more. So those are bills that you pay and the government makes revenue, but we don't call them taxes. Here's another issue to think about, and that's the second of the 3 cases we'll cover. This one is Strawn versus GAC Properties. This is a 1978 decision in the Supreme Court of Florida, but the facts were I tried to give you all like 1999 to the present cases in this book because I wanted them to have some relevance to you. I hate going back this far, but I couldn't resist the facts of this case. Did you notice the facts of this case? It involved 2 different just value assessments for one piece of land. I mean, you can't make this stuff up. There's a piece of undeveloped property. It's never been developed. It's never been subdivided. There's not a fence anywhere on it. But by happenstance or dumb luck, there is an invisible line that goes to the property somewhere. It's that invisible line that divides the county of Osceola, Florida, from the county of Polk, Florida. Now, you could try as much as you want with as good a pair of eyeglasses as you can find, but you'll never see that line on the property. It really has no relevance to the property other than the Osceola County property appraiser sending you a property tax bill, and the Polk County property appraiser is sending you a property tax bill. There's just one problem. Each constitutionally elected officer, and as we mentioned earlier, the Constitution of the state of Florida creates that office. Each one of them came up with a different just valuation for the same piece of property. What's the true just value? Osceola Property County appraiser says one thing, Polk Property County appraiser says the other. Who's right, who's wrong? Let's go to court and find out. What's the court say? You read the case? They're both right. Pay the property tax to Osceola based on what that constitutional officer came up with on that officer's assessment of just value, and pay to Polk based on the Polk bill that is based on the Polk County property appraiser and its different calculation, the same value, the same piece of land. You can't make this stuff up. Notes and questions to consider. Note 1, Strawn versus GAC Properties involved just a single parcel of land which happened to lie in 2 counties. One county said it was worth $300 and the other $500. How did it arise that this one parcel would be assigned 2 different values using the same applicable law? How? Doesn't the fact that there's 2 values mean that one officer's right and one is wrong? There's only one way we can look at this opinion and say that it was right. And that is to recognize each constitutional officer for what she or he is. And that is the holder of subsidiarity. Phrase sound familiar? You've all written me an essay or are still writing it. Can't wait to read them when I get them on subsidiarity. When it's done by the deadline, email it to me, patrick@mcginleylaw.com. Looking forward to reading it. Subsidiarity means that all power isn't vested solely in the highest sovereign. Subsidiarity means a lot of things, but one of the things it means is this. We recognize basic human rights. We recognize the authority of lesser sovereigns. We recognize the authority of both of these constitutional offices, one being the property appraiser of Osceola County and the other being the property appraiser of Polk County. Both were duly elected. Both applied the proper law. Both did a non-arbitrary, reasonable, and fair assessment. Subsidiarity respects the fact that each of them comes to its own conclusion that is right for its office in its county. This decision is correct because of subsidiarity. Note 3, why didn't the court find a violation of the just valuation requirement when 2 different values were assigned to the one parcel? And the one owner paid different taxes to the 2 counties. Consider the fact that at least one noted treatise opines, quote, the mandate of just valuation for property taxation has as one of its goals the uniformity of treatment of taxpayers, end quote. As the author of many treatises, treatises are like noses. Everybody has one, and every treatise voices an opinion. What's more important than opinion is black letter law. Black letter law tells us that you apply a certain standard to determine the just value, that you have the authority and some discretion within that authority, and that's what happened here. Each officer applied the correct law. Each property appraiser used the correct standards, and in executing his or her discretion, came up with a different value, and that's permissible. in our system. Let's take a look at some rather important things when it comes to homestead and when it comes to taxation. And this can be done through various cases, such as the one in the book. But what's not as important as knowing the case is in knowing the law. In Orange County Property Appraisers versus Summers, which is the case in the book, the court notes that the taxpayers asserted that their tax was improperly assessed at too high an amount. Then the taxpayers paid the tax anyway under protest, and thereafter initiated formal proceedings challenging the amount of the tax. Note and question to consider after that case, we're on page 391, asks this question: why did the taxpayers pay the tax despite believing it to be illegal? And this, my fellow lawyers and future lawyers, is important if you're going to practice this type of law here in the state of Florida. It's also important under the federal system, but I'm teaching a Florida class, so I'll stay focused for now. Here in Florida, we're talking about Article 7 of Florida's Constitution, subsection 13, which reads as follows: until payment of all taxes which have been legally assessed upon the property of the same owner are paid, no court shall grant relief from the payment of any tax that may be illegal or illegally assessed. Under this provision of Florida's Constitution, which I dare say is not different than the current state of federal law, in order to challenge the tax, first you gotta pay the tax. Is that fair? Well, it depends on whose perspective you're looking at it from. If you're looking at it from the perspective of the taxpayer, who honestly believes that this tax shouldn't be assessed or is illegal, man, that's not fair that I got to cough up the money just to challenge it. From the perspective of the government, I need, says the government, that tax money to provide valuable services to all the citizens. I assessed it because I thought it was fair and legal. If it turns out it wasn't, I'll gladly pay it back. But right now I got services to provide and money I need to provide them. So give me my money, says the government. So I guess it's a matter of perspective. But what the litigator needs to know is that you got to pay the taxes or you're going to get thrown out of court for having failed to pay them. Perhaps that's counterintuitive since you're challenging the tax, but you need to know that if you're going to do this kind of work. Let's talk some more about homestead tax exemptions. And remember, that was the segue that led us into this lecture on taxes and finance. Oh, I've got a question.
I'm sorry, real quick.
Yeah.
Assuming they take you to court to try and force a sale for your lack of paying the illegal taxes, can you use that you think the taxes were wrong or illegal as a defense?
No, you got to pay them.
So you don't have any standing to use the defense.
It isn't. You used the technically correct term when you said standing. It's a matter of standing. In order to have standing to challenge the illegality of that tax, you had to have paid that tax first. You lack standing if you fail to do so. Yeah, well chosen choice of words. Everybody got that? Yes.
It's very similar, like, when you think about it with like landlord-tenant law, because
Oh.
it keeps people from just not paying their rent and then saying, oh, it's not fair, because you don't have money.
Yeah.
Put money in the court holds it as a neutral third party. It's the same thing. They don't want
I like that analogy. And that's true in Florida landlord-tenant law as it is in so many other
Yeah.
states' landlord-tenant law. If you're going to challenge the certain issues with your landlord, the tenant's going to have to either first pay the landlord the rent or at least deposit the rent in the court depository where it sits out of the control of the tenant.
Right, so the neutral third party holds it, then it can actually be litigated fairly.
Yeah.
It keeps people from using this, like not paying their taxes because they don't have the money, but saying they're not. paying.
Yeah, I guess another motivation you point out is to avoid frivolous claims, avoid the misuse of the courts, avoid people just challenging things that they can't afford just to delay the payment. Yeah. Good point. Did you have your hand up? No? Okay. All right. So I promised to end where I began, which was some of these homestead exemptions. We're talking about pages 392 to 396. Over here, we're talking about how there was part of the homestead was an exemption on the ad valorem taxation, specifically on the property tax. We already covered how you take the just value, and if you properly applied for the homestead and it was granted by the county government, you subtracted $25,000 from the just value before multiplying the just value by the millage to get the property tax. And that $25,000 is not just for the millage and the property tax, but many of the other taxes. It will lower those too. There's more. I promised to end with it, and here it is. One of them is an amendment to Florida's Constitution that was called Save Our Homes. Very dramatic name it was given, and you can just imagine it was hard for the voter to stand in the ballot box and vote no. I don't want to save our homes. So Save Our Homes passed. Surprise, surprise with that name, right? Save Our Homes says that despite the just value of your homestead increasing year after year after year, Lord willing, because for a lot of us, that's the only retirement plan we have other than government benefits. We're going to sell our home, which is worth more than we paid for it. That's true of many Floridians. So Lord willing, the property value is going up and up and up. But as it goes up, up and up, despite you knocking off $25,000, the fact that it goes up and up and up might tax you out of your own home. Save Our Home says that there will be a gap between just value and this year's bill, because this year's bill cannot be any higher than 3% more than last year's bill. The end result is maybe on year one of your homestead, your property value went up 4%. Your bill's only going up 3%. By year two, maybe the property value is up 9% from when you bought it 2 years ago, but your bill is only up 6% from last year's bill. By year three, maybe your property value is up 20% from when you bought it 3 years ago, but this bill is only up 9%, this property tax bill, from what you paid 3 years ago. Over time, there is a gap if property values continue to increase. That's the amendment called Save Our Homes. But wait, there's more. That's my ode to Ron Popeil. May he rest in peace. Save Our Homes wasn't enough. We put before the voters, well, what about if you move from one home to another? What does homestead law say? Homestead law says that you get to establish a new homestead, but that you start over at the just valuation as of when you bought it. So the bill might be lagging behind for the former owner, but it's going to skyrocket for you. We didn't like that. So we amended the Constitution again. Save Our Homes portability, we called it. You make your deduction portable, by which I mean, you remember in our hypothetical, by year three, your property tax bill was only 9% higher than it was in year one, even though your property value had increased 20% by year three. There's an 11% gap there. We take that gap, we run it through a calculator, which you can find on the property appraiser's website, and you take that discount with you to when you buy the new house. Yes, your property tax bill is still higher than the old homeowner paid, but at least you get to take that discount with you. You still don't pay full value. What if it's not your homestead? Any cap? Hey, we amended the Constitution for that too. 10%. So you got some commercial property. Maybe you buy a condominium for your law office like I did. The property bill next year won't be any more than 10% higher than it was this year, regardless of how the property value goes up. Is that portable? So far, no. But hey, stick that on a ballot someday, and I bet it'll pass. I'll vote for it. And with that said, this is your summary of a very densely written chapter. I probably edited this chapter more than any other when it comes to notes and questions to consider, because I wanted to say so much in so few words, because I wanted it to be concise, and I knew that your patience for tax law was limited. With that said, I don't want to run over today. So thank you for being here. So far, we have not fallen behind the syllabus for even a single class this semester. Lord willing, I'll be able to keep it that way. I'll see you again in 1 week. And until then, may God continue to bless us all. And with any luck, maybe we'll have some working equipment next week. Who knows? Thank you. Good to see y'all.